bring in my think tank to do that. Criminal defense attorney Michael Bixon here, criminal defense attorney Jackie Patterson, and juvenile court judge Ashley Wilcott with us. Welcome to you all.
Thank you.
Let's start first with the fact that they're out, 7 hours, 18 minutes, 51 seconds. Quickly, one word to describe how you're feeling tonight about this jury.
Good.
Ashley.
I think the judge is being cautious.
One word, I said.
Good.
Good.
I'm going to stick with the common theme here of good.
Good. All right, you're feeling good. And you're feeling good, why? Because you think that, why?
Well, I think that they're taking their job seriously. They're going through all the evidence. And I think it's good that the judge has said, hey, I'm going to be cautious. It's only been 7 hours. Benny, that's not a really long time for a 1-week trial. So they're being cautious, and that's good.
Well, explain this to me, because I've not tried cases, but covered cases from around the country. And usually when you send out one note saying that we're caught up and you send out another one, you usually get an Allen charge or a mistrial, yet we're just going to continue deliberating. What are the rules here in Georgia?
Yeah, basically in Georgia, there's no time limit as to when a judge can give an Allen charge. What most people don't understand, the Allen charge has been around since 1896, decided by the U.S. Supreme Court.
What's the Allen charge?
The Allen charge is where when a juror says they are hopelessly deadlocked, then the judge will say, you are the best juror to decide this case. You all have had it. We don't need another jury. Go back and continue to deliberate. And then after a significant period of time, if they can't reach a verdict, then the judge would declare a mistrial.
All right, are there any rules on how many times they can send out a note saying we are hung?
I don't think so. And I think that we're a little bit ways away from getting an Allen charge. I mean, the case they really haven't been deliberating that long. 7 hours isn't that long for a murder trial. And when you're talking about felony murder, it's a convoluted sort of charge, right? They have to determine first the underlying charge and then get to the actual murder aspect of it. So there's a lot to sort of sort through, not only in terms of facts, but law as well. 7 hours is not that long.
Okay, so they're going to continue this tomorrow morning. Let's get to where they're hung up, which is the underlying felony is elder neglect. Do we all agree that if they're hung up on felony murder, then they have found him guilty of the underlying felony?
I would suspect so. I think that is good to reason from there that that's probably the case.
It appears that he's charged with 2 felony murders, one being elder neglect and the other one elder abuse. If they are hung up on elder neglect, I'm confident they found him guilty of felony murder based upon elder abuse.
So you're leaning towards, so it would be, okay, this is interesting because a lot of people have been saying the opposite today, but let's talk about that more. Just quickly, your thoughts. Are you confident, not confident, but do you think it's more likely than not that they found him guilty of elder neglect?
So far, yes. I think they found him guilty of the neglect, but I mean, obviously, they're still sort of out in the felony murder aspect.
Right, that's what they're trying to figure out. So let's just deal with that for a moment here. To get from elder neglect to felony murder with the underlying felony being elder neglect, what is that road? What would be the hang-up? We know that he died, right? We know, in presuming that they found him guilty of the elder neglect and he died, how close does that connection have to be?
So you need some type of connection, and there's different sorts of tests that different judges are going to throw around, whether it's the approximate cause, but there does have to be a connection between the actual offense and the death. You know, if I go and I rob a bank and then a month later somebody dies, it's going to be a lot harder to make that type of connection. But if they were in a coma as a result of me robbing that bank, they got hit in the head or something, they die later, it is arguable that
so the
like
elder neglect here, we all are believing is the part where he admits on video that he was reported to him by Mr. Bennett that he was in pain and that he didn't do anything. He didn't call a medical tech.
That is correct.
Right?
That would be the elder neglect by not calling 911 and getting other people involved.
So how do prosecutors get from that to the felony murder? How do they get connected?
I think they just say that because he failed to make that call, because he neglected his attention to this particular elder, as a result of that, he died. It caused his death. There was some proximity to cause result in the death.
Well, here's my question, because, and this gets to the other felony murder, which is the underlying is elder abuse, right? I look at the facts here, and the way I see it is that the death is caused by those injuries, right? And he was going to die, and there was nothing that could have been done to save him once he sustained those injuries, right? So is it the neglect or is it the assault, or is it both?
I think that's what the jury's struggling with.
That's correct.
What
And
you just said.
And I believe that it's going to be more of the elderly abuse because there's testimony that he struck the patient and the patient died within 48 hours later. So if the jury believes that his death was the proximate cause of that striking of that blow, then that would be felony murder under elderly abuse.
So based upon where we are right now with this jury, you believe it's possible, or you think it's more likely that they have found him guilty of felony murder with the underlying felony of assault and are hung up on this concept of neglect.
I do. Absolutely.
Do you guys agree?
Not necessarily, and here's
Okay.
why. I mean, between neglect and abuse can be a higher standard, and the fact that they're so caught up just on neglect, I don't know if they're going to quite be able to get to abuse, which is sort of a little bit higher than it, right? I mean, if I just let you lay on the floor there and that's my neglect, that's different than actually striking you and intentionally injuring you. The fact that they're so caught up on the neglect, I don't think they're going to be able to get to abuse.
And I disagree. I think the striking is the abuse, and I think that's the injuries as a result of the abuse. I think that's going to be easier for a jury to determine based on the evidence than the neglect.
See, this is fascinating because the discussion today on Court TV, much more similar to what you were saying, Michael, which was a lot of people here were believing, based upon this, that they're caught up on the neglect. They've probably already found him not guilty of the assault, not believing beyond a reasonable doubt that he caused those injuries. But I could see it playing both ways here.
Absolutely.
The only thing I am reasonably sure of is that he is guilty of the neglect, which is the third charge, which is 1 to 20 years. So let's presume that's it. That's the only thing he's found guilty of, 1 to 20 years. What would happen to a guy like this? He has no prior criminal history, and he's already served 2 years waiting for this trial.
As a judge, I think if that were the only charge he was convicted of, he would have a low sentence. I think it would be closer to 5 or less.
5 or less?
I totally agree.
Is it possible he walks with time served?
Not at all. I think it would be more like 20 years to serve 5.
Okay.
Yeah, I'm somewhere between 5 to 10, I'm guessing, in terms of what he'd actually be sentenced to. But I do agree. I think so far he's been found guilty on number 3. I think that one's a foregone conclusion. I think 5 to 10 years.
And then, so the big question, I mean, you're talking about a big difference here if he is found guilty or not guilty of the felony murder count 2 as this jury comes back tomorrow morning. All right, coming up, we're going to talk about a little more detail when it comes to what he admitted to and what this neglect may all be about. The reenactment video the jury watched in court, where Landon Terrel explains what he says happened, we're going to show it to you. All right, the verdict watch continues in Georgia versus Landon Terrel, but today the jury sent out a note saying, we've reached a verdict on 4, but that count 1, we are hung. And they sent out a couple notes on it, but they will continue deliberating tomorrow. Count 1 again, felony murder where the underlying felony is elder neglect. So where does this elder neglect come from? It comes from the mouth of Landon Terrel, who does that video reenactment the next day. Police officers bring the video camera, so the video work isn't great. The audio is okay as well. That's just the way police officers are with video equipment. But it's important evidence in this case, really important evidence for prosecutors. I've got a piece of it here where he talks about what he didn't do. And that was one of the themes for prosecutors. It's not just what Landon Terrel did, it's what he failed to do.
Make any comments to you when that happened?
Yes.
What do you say?
He instructs you say, don't do like that.
Did he point to anything?
He ain't going to like that.
Okay. He didn't say anything else, did he?
He was in pain, as we told you. He was in pain.
Okay. Now, he told you he was in pain. What did you do?
I did not get a mental.
Okay. And why was it?
It was poor judgment.
91-year-old Adam Bennett said he was in pain. He said that to the person who's charged with taking care of him, right? I mean, that's his responsibility at this assisted living facility. And he admitted right there. He said he was in pain. It was in poor judgment, but I did nothing. That is your elder neglect. All agree that that is really what we're talking about. It's an admission.
Right.
By the
Absolutely.
defendant.
When you don't pay attention to them and you don't take care of them, that by its definition is neglect.
Okay, so how Is there an argument for the neglect causing the death in this case? Because I think the defense put on a lot of evidence about prior falls that he had. He's 91 years old. He was in World War II, survived World War II, for goodness sake. But the fact that the neglect, the not calling the doctor or medical personnel right away.
Absolutely. It doesn't matter how bad of a condition and how frail the gentleman was. The issue is whether the defendant acted or did not act in a reasonable or negligent manner, and that's where the neglect comes in at.
Okay.
I think the only thing is there's an argument for it, but an argument isn't necessarily beyond a reasonable doubt. And there is doubt here, and I think it is very reasonable to say that it wasn't maybe his neglect that caused the death, but it could have been these prior falls. It could have been something else. We know his such poor health. So is there an argument for it? Yes, but I don't think it necessarily gets you beyond a reasonable doubt.
And you mentioned prior falls. In that same video, reenactment, Landon Terrel, the defendant, describes how he says the victim, Mr. Bennett, suffered those injuries. He was in there changing him like he's supposed to do, and he said he was like falling off the bed, but he caught him before he hit the ground, but his body banged up against the rail guard on the bed. Take a look.
So then he falls, and
No, he proceeds to fall and I catch him.
you catch him.
Yes.
You stop him from hitting the floor.
Yes.
Okay. He's a big guy,
He is a big guy.
but you have no problem stopping him from hitting the floor. Okay. Then what happened?
And I proceed to lift him up. That's when he turned and hit his chest.
All right. Was everything here when that happened?
Right here?
Yeah. Is that there?
Yes.
Was the nightstand there?
Yes, everything was right there.
Okay. So where was his head in regards to the nightstand?
His head was not that far from here. I feel like it was a good distance where his head was.
Okay.
Now, if you notice that, if he's falling off the bed, the injuries would have been on the right side, because that's the part that's closest to the bed, as described by the defendant himself. But all the injuries are on the left side. So, in order for the jury to believe that these injuries were not caused by Mr. Bennett, there would have to have been some sort of intervening subsequent fall when he was ignoring his patient after he fell off the bed. There had to be even more falls off the bed.
Absolutely.
That's the only way I
Unless
see
there was
it.
something happened before.
So it's a pre-existing injury?
It could be. I don't know. I mean, look.
From when?
Well, from any time. I mean, look, these nursing homes are understaffed and the staff are underpaid, they're overworked. Who knows? It could have been any time. We aren't there. And for us to sort of jump in and judge and say, this is exactly how it happened, we don't have recordings of this.
Well, what we do have, though, is the words of the victim telling the other workers there that I got hit here between the legs where there was a severe injury, hit here where there was another injury, hit here where there was another injury. He described those injuries and being hit by someone. Do we not believe him?
I do. And to play devil's advocate, the other issue that I have is, hey, listen, what defense are you going to have? The defense you're going to have is he's elderly, he's gotten these injuries along the way in different places because elderly are more likely to fall, etc. That's the only defense you're going to have. But I found him very credible in what he had to say.
And one thing that the prosecutor pointed out, I thought this was the best, I don't want to call it a line because a line doesn't sound like it's genuine, but the most important thing that he pointed out factually about this case is every time that Mr. Bennett fell in the past, he told people that he fell. This was the only time he'd ever said he'd been assaulted. Like if he had a history of telling people I was assaulted, they'd keep hitting me, that would be one thing. But every time that he fell, he admitted that he fell. He said that's what happened, I fell. This time he didn't say that though.
And the defense certainly argued about the fact that he has memory problems. But at the same time, no matter how many memory problems or issues that he always said that he was hit by the defendant. And I think that's the most telling part. And then the victim also told a relative.
Yeah, so what's your experience, and maybe you don't have any necessarily with people in court who are 91 years old, but I think society generally, do we start disbelieving people at a certain age and we're afraid that they're, especially if they're in assisted living and they may have some issues that they're just not credible enough to believe beyond a reasonable doubt?
I think you take it with the understanding that there might be issues along the way. And we have certain laws in Georgia that are set around for people who are in either, more critical stages of their life. I mean, in Georgia, we don't have, for instance, like depositions in criminal defense. But if you're maybe close to death, or if you're elderly or something like that, then you might be able to have one. The law recognizes that they're sort of at this vulnerable state in their life. When there's and they sometimes go hand in hand, obviously, when you're elderly and you might have memory issues. I think the juries understand that that can be an issue. Now, does it mean that you automatically don't believe them? No. But you do take it with a grain of salt, understanding there might be issues.
And how much of a challenge does that become for prosecutors? Because you sort of, in this case, need them to believe him beyond a reasonable doubt.
Or at least be sympathetic, absolutely, so they find him credible. But that's why we have the elder abuse laws. That's why there is legislation. There are things to protect those individuals, because their memories may not be as good. They may not physically be in the same shape they used to be, but that doesn't mean they're not credible. It doesn't mean he has no motive to make that up. And so you take your victim as you find them. That's what the jury hears.
And that's why the problem is that you got to deal with the factual issues. You got to deal with what the defendants say happened, and then deal with what the prosecutors say happened. And that's why we have jurors that's going to deal with beyond a reasonable doubt.
You know, and during the course of these deliberations, they sent out notes as well, and some of them had to do with the elder law and who's liable and who's not liable. And to me, that seemed like it was helping, could help the defense. So where we are now with verdicts on all four, how confident are you that they can bring this thing home? With verdicts on all five, or do you think it's possible they end up getting hung on one?
I think they're going to get hung on one. I think even though they have to continue to deliberate, we're at 7 hours, I do not think they're going to resolve that one. I think it's going to be a hung jury on that.
And I happen to agree with the judge. I totally agree.
Same here.
All right. I tend to agree, too. And the more I think about it, Jackie's got me thinking tonight, really, because if someone is holding their ground on guilty on felony murder for the neglect, could they have very easily said not guilty for the assault felony murder? I think that's almost more difficult to do. I'm thinking on the spot here. Usually I have my mind set up, right? I have my mind made up. You've seen me before, but tonight I've got different opinions here, and it's making me think.
It is no doubt in my mind that it's easier to prove elder abuse versus elder neglect.
Because it's easier to understand abuse and the injuries than it is to understand neglect and what injuries that causes.
All right. Wow. All right. The jury will continue their deliberations. Coming up, we're going to switch gears here. Talk about former teacher Britney Zamora. Who is she? Oh, she's a woman. There she is, getting arrested. She was on her way to school to go teach class. 6th graders. Well, one of her students, a 6th grader, 13 years old, is her victim of sex abuse. Another 11-year-old was also one of her victims. She got him to be the lookout and made him watch. We've got her sentencing coming up as she speaks on behalf of herself, looking for leniency.
Thursday night on Court TV.
25 years ago, O.J. Simpson stood accused of murder, a case an entire generation remembers as the trial of the century. Kim Goldman, sister of murder victim Ron Goldman, has released a podcast with never-heard-before details. She'll join us live in studio to share exclusive content from her podcast interviews.
Closing Arguments with Vinnie Politan. Thursday night, starting at 6/5 Central on the all-new Court TV.
She'll be like, oh, yeah, I love you, and I'll tell her I love her too.
We're suing the school district.
And Britney Zamora is a monster.
And then she was like talking about how she wanted to do stuff with me.
You are a pedophile. You're a child molester. Do you understand me?
I wanted you to explain, how this came to happen.
Can I wait to have an attorney?
You can.
Principal Timothy Dickey's failure to act when he became aware that there was an inappropriate relationship going on.
That's crazy.
A relationship
That's
with a 13-year-old boy.
crazy. I can't even connect that.
Did you have sex with your teacher? You said yes.
3 6th grade girls were alarmed enough. I mean, it was obvious enough to them that something was going on that they actually wrote notes to the principal.
I got to be honest. You hope it's not true. I think that's the very first thing that you say to yourself.
The first sex act occurred just over a week later.
No, I want to know. You said she confided in you. Let me know what she told you so I can tell you she told you everything.
There was oral sex in Britney Zamora's car.
Ms. Zamora, do me a favor. Do not call this number back again. The next time you'll hear from me will be in court.
Britney Zamora is a former elementary school teacher in Arizona who pleaded guilty to sexually abusing one of her students, a 13-year-old boy. Well, now she knows how long she'll be spending behind bars. A judge sentenced her to 20 years in prison, not giving her the maximum possible sentence of 27 years, even though she admitted to multiple sexual encounters with the boy in a classroom and other places at the school in the Phoenix suburb of Goodyear. Now, at least one of those instances happened while other sixth graders were watching a movie in class. Now, her victim's family did not speak during her sentencing, but their attorney did. But the victim's father made his feelings about Zamora very clear when she picked up the phone and called them. That's right, she's calling the parents of her 13-year-old victim after they learned about the allegations.
What type of perverted person are you? I want to know right now. You are a monster. You are a pedophile. You're a child molester. Do you understand me? No.
Why do you say that?
Oh, bitch, see, I'm a lot smarter than you. I'm so much smarter than you. You do not understand how much smarter than you I am. I got you. I want you to know that now. I got you. Do me a favor. Do not call this number back again. The next time you'll hear from me will be in court. And make sure you let your husband know that you like 13-year-old boys. And I want you to do me a favor. Do that for me, okay? I am coming for you.
All right, I want to take you inside the courtroom right now for Britney Zamora's sentencing hearing, and on the stand testifying on her own behalf, Britney Zamora.
I want to start off by apologizing to the victim and his family. I'm sorry for any undue stress or pain that I may have caused. I'm ashamed of my actions and am completely remorseful and truly regret what took place. I'm known to be a responsible, caring, happy, and thoughtful person. My actions were completely out of character for me. As an adult and teacher, I am meant to set an example, and I did not follow according to that expectation. Prior to this incident, I have been an amazing teacher and citizen. I started programs while teaching to help stop bullying, teach girls about nutrition, fitness, create fundraisers to help with autism, and help families in need. Filled 25 plus desks with school supplies each year, and even won Teacher of the Year in 2016. As far as a citizen goes, I've lived my life respecting and trying to obey every law. I am not a threat to society by any means. On the contrary, I have tried to help our society as much as I can. This includes helping out the homeless, volunteering for the city, and giving time to assist with church programs. Over the past 16 months, I've grown within my faith, and that has helped me not only get through each day, but has led me to reflect on how sincerely I took life for granted. A life that I've been working so hard to set up for a successful and bountiful future. I would do anything to re-enter society sooner for a second chance. This sentencing is not only taking decades of my own life and experiences away, but those of my loved ones as well. My family knows who I am and my heart, so it is just as hard on them. Therefore, I would also like to apologize to them. As stated earlier, I never want to hurt anyone, and it tears me apart to know that I have, and I'm deeply sorry. Going forward, I would like to attend counseling and all other required courses, obtain a new degree, and seek new employment. I have already relinquished my teaching certification. My hope is to rejoin society a better and more grateful person. I have an incredible support system and know they will all be there for me every step of the way. Your Honor, I know the state did not take my mitigation and assessments into consideration, but I hope you can. I am a good and genuine person who made a mistake and regrets it deeply. I ask that you please have leniency in regards to my sentencing, that you see me as a person with a hopeful future and not just another number or case. Thank you so much for your time and consideration.
Thank you for your statement. All right, the court has considered the nature and circumstances of the offenses. The court has identified aggravating and mitigating circumstances and weighed and balanced those circumstances. As aggravation, the court finds the defendant's conduct caused physical, emotional, and financial harm to the victims. There were multiple victims. The defendant violated and abused a position of trust. I find the circumstances of the offenses to be especially aggravating, and the fact that these events occurred over a period of time. I also find as aggravation the defendant's efforts to conceal her conduct from others. As mitigation, the court finds the defendant did accept responsibility by pleading guilty. She has expressed her remorse. For amended count 1, the court finds that the presumptive term is appropriate, so it is ordered the defendant be incarcerated in the Department of Corrections for 20 calendar years with credit for 478 days of pre-sentence credit. As to amended count 2 and amended count 15, it is ordered suspending the imposition of sentence and placing the defendant on supervised probation for a lifetime term to begin upon physical release from the Department of Corrections. The terms and conditions of probation are in writing. You will have an opportunity to read and sign those terms shortly. When you sign the terms of probation, it indicates to the court you understand and will follow those terms. If you do not follow those terms, you can be returned to court and found in violation. Your probation could be revoked and you could be sent back to prison for the maximum term provided by law for each of these offenses for counts 2 and 15 as amended. Do you understand?
Yes.
You are to follow all of the standard terms and conditions of probation. In addition, you are to have no contact with any victim. You are not to return to the scene of the crime. You are to follow the sex offender terms of probation and the computer usage terms of probation. As financial assessments, there will be a $20 probation assessment on amended count 15. All other financial assessments will be on count 2. There will be a $500 sexual assault assessment, a $65 per month probation service fee, a $250 sex offender registration fee, a $20 probation assessment, a $2 victim rights assessment, a $50 address confidentiality assessment, a $20 time payment fee, and a $13 criminal penalty payable to the Goodyear Police Department. As provided in the plea agreement, it is ordered that counts 3 through 14 are dismissed. Do you have any questions about any aspect of your sentence?
No.
You have 90 days from today to file a notice of post-conviction relief with this court. You have the right to have an attorney represent you. If you cannot afford an attorney, one will be appointed for you. If you cannot afford the necessary records and transcripts, they will be provided for you at no cost. Do you understand?
Yes.
Okay, so she didn't get the maximum, which was 27 years under this negotiated plea agreement, got the minimum under that, and the defense was like celebrating today. We'll show you that in just a little bit. But there was one thing that really ticked me off during her little statement, talking about mitigating factors. I've been an amazing teacher. Think about that for a second. You know, people who want access to children enter, you know, they volunteer to be coaches. They get into teaching to have access to children. So to try to use that as a mitigating factor, good news was the judge did not buy it at all. But could you imagine, like, if some creepy, hairy soccer coach, you know, got up in court and said, well, I'm a great coach. I'm a great coach, and that's a mitigate. That's why you should sentence me to less after he molests one of his players. It's the same thing here, right?
Because she doesn't even realize she's a perpetrator. She says that she's remorseful. She doesn't get what she's doing is wrong. And that's why she will always be a perpetrator, in my opinion.
And it is no question, Vinny, that power, when abused, is dangerous. I've represented police officers that have arrested people and actually assaulted them in the patrol car. It's the nature of the power. Some people can't handle that. And that's why people like her begin teaching careers because they can take advantage of small children.
You know, there's one other thing that bothered me, Michael, was, and it was in the pre-sentence investigation, she was interviewed. She was remorseful, you know, when speaking in front of the judge, but when she was interviewed, she was talking about how aggressive this 13-year-old was, like sexually aggressive. And then we're going to show you the press conference coming up in just a second. You're going to be outraged by it. But just her own words talking about that, I mean, that's kind of outrageous.
Yeah, and let's be clear. If this situation were with a male defendant, it would have been a completely different result. There's no way.
Even more time, you think?
Oh, without not even a shred of a doubt. I guarantee it. I mean, she basically got the minimum, right?
Under the plea agreement.
Under the plea agreement.
The only reason I feel like there's some justice tonight is because years ago I covered another case kind of like this, 12-year-old victim, teacher, blonde hair, big blue eyes, right? And she got home confinement because her attorney successfully argued that she was just too hot or too pretty for prison, and the judge bought it.
Can I just say,
So at least that didn't happen here.
And this is one of the biggest sentences. If you look across the board nationwide, this is one of the biggest sentences handed down to a perpetrator like this. And that's bad. This should happen more often. More individuals.
Are we turning the corner?
For females should get this.
Oh, yeah, absolutely.
For females, not males.
Generally, they are way lower. I mean,
I completely
and you are
agree.
correct. Yeah, this is on the high end. But for overall, this is still on the lower end.
Why are we still, I mean, the law makes no distinction between who the victims are and who the perpetrators
Society
are.
does, though. Society does. And I think we all recognize that they do treat them very differently.
But they shouldn't.
They shouldn't. And hopefully we're
should
turning
not.
the corner.
No.
All right, coming up, I got to show you this. This is the press conference. So you heard him in court being all nice with the judge. Wait till you hear what Britney Zamora's attorney says afterwards, and she reads a statement from her client as well. That is next. All right, we've been taking a look at the sentencing of Britney Zamora, again, getting 20 years. So after they're in court, you know, talking about remorse and everything else, then Britney Zamora's attorney holds a news conference. You watch it while I get my soapbox.
Good afternoon. Throughout the life of this case, there has been significant misinformation given to the public. Britney has been wrongfully portrayed by the state of Arizona and the press as being a predator and has even been called a monster. I have represented Britney Zamora for almost 16 months, and I can tell you that she is not a monster. Britney is not a predator, and this was not between a young child and Britney. This was a teenager. Britney underwent a psychosexual evaluation, and she passed with flying colors. She is not a danger to society. There were issues in this case. For example, Principal Dickey refused Britney's request to move the teenager out of the classroom. Britney Zamora implored Principal Dickey to move him because the teenager had boundary issues and was obsessed with Britney. I am not making that up. I learned that from Principal Dickey. All things that were outside of the evidence that probably you all received. The teenage family's attorneys filed the civil suit within hours of the issue coming to light to the police department. The teenager had 2 cell phones. He had multiple social media accounts for the same place. His family had Principal Dickey's cell phone number and would call him at any time they wanted to speak with Principal Dickey about his many behavioral issues. I see some of your faces frowning, but I learned this from Principal Dickey during a defense interview. The teenage boy was very aggressive. He even was very persistent in asking Britney about her birthmarks, molars, or anything else that could be an identifiable piece of information. This was before the authorities were contacted. Now I'm going to read you the statement from Britney. Good afternoon. My name is Britney Zamora. Thank you in advance for hearing this statement. After going through the court process for the last 16 months, I can truly say that I have been unfairly treated by the state of Arizona. It is shocking to me how others are so quick to judge based off hearing accusations from only one side of the story. It was made clear to me that the state had already made their decision well before I was given a chance to prove my innocence in any way, shape, or form. Even after obtaining extensive mitigation, completing risk assessment, psychological tests and evaluations, and polygraph tests, all of which proved the highest degree of character, the state decided to turn a blind eye to all. I feel like I was used as a publicity act to gain attention that was often driven by money, motivation from several parties. I am here to tell you that I'm not a monster the media has projected me to be. I am kind, generous, responsible, and a caring person. I have always proven to be a person of great character, working selflessly to help people in countless ways, from setting up programs to stop bullying, to creating fundraisers for people and families in need. I have an amazing support system that I'm very thankful for, and I pray one day I can help others to avoid going through the same unfair process. I also hope that our society can learn not to judge each other based off the way that information is biasedly portrayed, because I know firsthand how it feels to be viewed as someone that you're not. Thank you. That is Britney's statement. I can tell you that I, as a criminal defense attorney, advocate for people who are charged with a crime, people who are wrongfully charged with crimes and wrongfully prosecuted. In this case, Britney was not given a second chance. In spite of everything, she was not given not even a single day outside of the plea range that was initially offered. However, I'm happy to report that today we were very successful. She was sentenced to the minimum allowed by the plea agreement, and to us, is a win. Thank you for your time, and we will not be answering any questions today.
Oh, I have some questions that I know you're not going to answer, but Belenguera is her name. Did you believe what you just saw? Because I've got my think tank here. I'm going to unleash them in just a second and let them give their takes, because they do the same job that this woman does as a criminal defense attorney. We need them. They're part of the system, et cetera, et cetera, et cetera. But let me, just one point that just is grinding my gears tonight. This was not a young child. This was a teenager. He was 13. He was in 6th grade, elementary school. My guess is that lawyer probably doesn't have children. I don't know. But if she does, that scares me tonight a little bit. 13 is a young child. Any of you who have a 13-year-old at home know exactly what I'm talking about. 6th grade. That is a young child, and that's who the victim of this case was. Now, there's a lot more that needs to be unpacked about what just happened there in that press conference. Bring back in my think tank. Who wants to go first?
Vinny, it is no doubt that there are two victims here. One is the real victim, which is a 13-year-old boy, and you have a fake victim, which is the defendant in this case. This lawyer, this has to be her first high-profile news conference. It is no question in my mind that her career is never going to go any higher. This was the worst If a lawyer could be disbarred based upon bashing a victim, a child, she would fit into that category.
Yeah, I'm trying to figure out why she's speaking.
It is the most ridiculous, even to hold this press conference over the issues that she did. I mean, it is the most blatant example of victim shaming and victim blaming. And that's one thing, but when you have a 13-year-old victim, are you insane? Why would you hold this press conference? What purpose could it possibly serve other than your own? I mean, this is
But I don't think
crazy.
it serves her.
No. I mean the attorney.
Right.
And there's an argument, I think, to at least get your name out there, but why would you want to do it in this kind of manner? I mean, look, if this were a male defendant, there would have been lynch mobs there. She would have been taken out back.
How about if it was a 13-year-old girl who had been sexually molested?
Exactly. The man would have been, and an attorney comes out and says this about their male client.
Forget it.
But it's so unbelievable because you cannot blame a 13-year-old. You can't blame any victim for what happened. And she keeps wanting to say, oh, it's an injustice. Well, who took the plea? Who decided to advise and say, oh, there's so much evidence, you better take the plea? If you're going to accept a guilty plea, it's the same as if you went to trial and were convicted.
Right. Now, she did her job. She negotiated a plea, the best plea possible for her client, and her client will have a life when she gets out of prison. She'll be in her mid-40s, still young and able to live a life, right? She'll have to report and she'll have to register and all the things that she has to do. But she did her job, but then she did this. And to me, this crosses the line between being an advocate and bashing a 13-year-old boy.
I completely agree. I mean, this is so far beyond what was required of her. And it just serves I don't even think it serves her client's purpose. There's just nothing for her client.
Now, how about if the judge watched this afterwards?
Gosh, I would.
If you were the judge, if you were the judge in this and you saw what took place after they left court, and part of that was Zamora's own statement.
Right.
Not taking responsibility for what happened, unlike what she said in court, oh, I have this remorse. And then outside of court, the truth comes out.
I got to tell you, I don't know what the law is in that state, but if I had the ability, the discretion as a judge to say, come back in because it's this many days to talk about this, I would bring them right back in to reconsider the sentencing. I would if that were allowed under that state's laws.
Because Zamora is basically claiming her innocence there, saying, I didn't do this. There's another side to this whole thing. I would bring him in and say, all right, let's get rid of the plea. Let's go to trial, and you're facing the rest of your life in prison.
Completely agree.
And when she said, I talked to the principal, begged the principal to remove the child, why not remove her instead of the child?
Yeah, I don't understand. There's a very easy way to not molest a child, Britney Zamora. You don't molest the child. It's that easy. It's simple. And if you feel the irresistible impulse that this child is just coming on to me so much that I'm not going to be able to resist the words of this 13-year-old boy, then you've got to tell the whole world. Call his parents. Say, hey, your son is out of control. Do whatever you got to do. But you know what you're not supposed to do. And she didn't just do it once. And don't forget there's victim B here too. That's the part of the press conference that's completely ignored. Victim B, the one who was forced to watch it, the 11-year-old. The 11-year-old who was also, according to his mom, being groomed by her as well. All these kids growing up way too fast because of her actions. And like I said before, for victims of child sex abuse, for them, it is a life sentence. They have to live with this the rest of their lives, figure out a way to overcome it, to battle it, to deal with it. So at least for Britney Zamora, in some way, it's a life sentence as well because she has to register as a sex offender. She is under the thumb of the court. If she violates the terms of her lifetime probation, then she'll go back into prison. So at least that is hanging over her heads, and she's gone for 20 years. All right, folks, what's next? The next big trial here on Court TV, Florida versus Grant Amato. This guy, apparently obsessed with a webcam girl, and commits a murder as a result, according to prosecutors. We've got that story next.
I'm Seema Iyer. Some people say I'm tough. Maybe it's because I was a prosecutor in the Bronx. I may have earned it as a lawyer representing the NYPD. Or it's because of my expertise in forensic science. Sure, some people call me tough, But on court TV, they call me the queen of crime.
The all-new Court TV, your front row seat to justice.
All right, we're turning now to Court TV's next big live trial. Jury selection underway in Florida versus Grant Amato. Now, here's what investigators say happened. Grant Amato, 29 years old, living at home when he massacred his parents and one of his brothers because he was kicked out of the house after stealing about $200,000 of their money to feed his online relationship. Who was that with? Well, the focus was this woman. This is a webcam girl who lived in Bulgaria that he met through a porn webcam site. Now, police say Grant Amato shot his 61-year-old mother, Margaret, 59-year-old father, Chad, and 31-year-old brother, Cody, on January 25th. Court TV crime and justice reporter Julie Janae was in the courtroom for jury selection today and has the latest for us.
Jury selection here at the Seminole County Criminal Justice Center continues tomorrow with more questions and vetting of the potential pool of jurors. There were 100 today who were asked questions by the state and the defense attorneys trying to understand if they have, number one, scheduling conflicts, if they have any knowledge of any of the parties, the victims, or the attorneys involved in this case, or if they have seen coverage of this in the media. And there were a lot of people out of that pool, nearly 50%, who had already seen coverage and understood something about the case. This is a more recent case than normal. It happened only 7 months ago. So many of those jurors reported and they watched media coverage as early as this morning before they came in for jury selection. So a lot of today was spent going through those jurors individually, asking them questions about whether or not they could set aside what they've seen in the media and still be impartial jurors. Most of those jurors who saw other coverage were able to continue being a part of this pool, and the 14 that we saw dismissed were mainly dismissed by agreement of the parties or for cause because they had a scheduling conflict. Now, Grant Amato, during all of this, the one who is accused of murdering his mother, his father, and his brother, he sat very stoic through jury selection. He had a faraway look in his eyes when he sat at the defendant table, and for the most part didn't make eye contact with these potential jurors as they were being questioned. Now, tomorrow, several groups of those jurors are going to return for further questioning from both sides, and we'll of course be here and bring you the very latest. Vinny, back to you.
All right, Julie Janae at the courthouse. By the way, same courthouse where George Zimmerman was found not guilty several years ago. Now, this case, there was an arrest of the defendant, and when he's arrested, you know, there's usually these interrogations, and we have the interrogation video where you see him being questioned by police. Well, while he was in that room and when police stepped out, Grant Amato's surviving brother, his baby brother came, his younger brother, came and visited him, and they talked about what happened. This is heartbreaking, captivating, and perhaps really important evidence in the case. Take a look.
All right, so I take it you know what happened. Yeah. I'm going to ask you plain out. You are not part of it anyway. No. When's the last time you saw everybody?
I left the house between midnight and 12:30.
On Thursday night? So Friday morning?
Thursday going into Friday.
Why? That's when you went to a hotel?
No. The first night I stayed just in the Publix parking lot by the Tractor Supply.
Okay. And why did you leave, though?
It's because Dad had kicked me out Thursday because I was still talking to the woman that had caused everything, and I was using Mom's cell phone to do that with her knowledge, but not Cody or Dad's. So then Dad found out somehow, and that was one of the things that he had said would lead to my being removed from the premises.
So he forced you, he basically told you you had to leave.
Yeah.
Okay. So who could have done this?
I don't.
So you didn't have any problems or troubles with this woman or the online? You didn't owe them any money?
No,
I mean, there's no like loan shark out looking for you or...
No.
I just don't see how things aren't adding up. I'm really confused, Grant. I don't understand. How did you get money to pay for a hotel?
I still had a few $100s on my debit card, and then Cody gave me his debit card.
Okay. And I don't know. I want to believe you, Grant, but you're the last person that I could put in that house. And I know what happened over the last 6 months. I can understand the troubles that you've gone through, but it's hard for me to think that you would break to this point.
Mm-hmm.
But who else can I blame? How are we going to find out who did this?
I don't know. I don't have the answers.
So what are your intentions? Do you understand what we have to do now? If you're not the person that did it, we have months of stuff that we have to take care of from our dead parents. Months. You know how much stuff is in that house? We have to go through it all. I have to call people in California to let them know that Margaret Amato is not alive anymore. I got to call at 3 o'clock in the morning because Cody's 30 years old and has perfectly good organs to donate. And I can't call that shot. He's not an organ donor. I had to say no. So that means there's someone out there that could have used his organs, but we weren't prepared for this. I love you more than anything in this world, just like I loved Cody, Grant, and Dad. I know Dad was I know Cody was but they were our family, and they would have never done anything to hurt us.
Mm-hmm.
The you did, you could have been in jail. You would have been in jail for years.
I know.
And they covered it up for you.
That is so heartbreaking. Imagine being the youngest member of that family, and your mom is gone, your dad is gone, your oldest brother is gone, and now your older brother's charged with these deaths, and he, by the way, is facing the death penalty in this case. What do you do? How do you recover? Our thoughts are with him because he did nothing here, obviously, and we'll see what the jury says about what happened. But this is a tough case, but I want to talk about one issue here, and we just have a minute. The obsession with this webcam girl. I see prosecutors using that as the key piece of evidence during their case to prove motive and why he would do this. And then if he's found guilty, I see the defense using that as a mitigating factor as to why he shouldn't get the death penalty. Is that possible?
Agreed. Absolutely, it's possible. You can use it on both hands. I think the defense can do that, and I think that that's probably what they would do.
You know, Benny, I don't even think the motive is the real issue here. The issue is that he's going to be convicted on this video we just saw. You've got one brother who's distraught in disbelief, and if the other brother is the one that's accused, if he's innocent, he would be kicking and screaming and saying, man, are you crazy? I would never kill mom and our brother. He was so just there. It is clear his conduct in that interview that we saw with his brother is going to get him convicted.
I completely agree. That video looked terrible for him. I mean, if I was the defense attorney, I would try to anything I could to keep that video out because that video, I mean, look, I don't know what kind of forensic evidence they have yet. I think it's going to come out, but that video just nothing for him, nothing at all.
Yeah, I mean, it shows that there's trouble in this family, talking about 6 months. We've been trying to, you know, I know what's been happening for 6 months. So I got to think everything that's been happening for 6 months can become part of this trial, all the turmoil within this house.
Absolutely, which is part of the motive.
And the premeditation. I don't know what the evidence is yet, but those 6 months before, there may be things he's done to show that it was premeditated. We don't know.
Now, we haven't seen a witness list yet, and the webcam girl is from Bulgaria. I mean, I don't think prosecutors need her, right? They can rely upon the records and the videos and the trust me, we've seen some of these photos that will be evidence, things that you won't see here on court TV for sure, but the jury will probably see in the courtroom. So you probably don't need her as a witness.
And they still have all the financial records showing how much money he had, and hundreds of thousands of dollars to this woman. I mean, I think if anything, that's enough. You know, so I don't think they need her. They have enough, you know, financial records and other records between him and her to, I think, justify any type of motive that they're going to claim on his part.
Unless he admitted something to her by cell phone, by oral that wasn't recorded, then yes, they're going to want to bring her over.
All right, we'll continue. That's the next big trial here on Court TV. Jury selection continues tomorrow.